Hello and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular set of videos we are discussing about the CSPA and the provisions of the CSPA. We've done a few on how to calculate the age of a particular child to see if they fall under, again assuming it's not an immediate relative petition. And one of the elements is that that particular person had sought to acquire the immigrant visa within 1 year after it becoming available. So again, after it became available is the first day of the month on the visa bulletin where that particular visa was available. So the question is, what does sought to acquire mean? Well, the date the child seeks to acquire, that's a term of art there, seeks to acquire lawful permanent resident status for purposes of the 1 year filing deadline for the immigrant visa application, is the date the beneficiary child, not the parent, submits the completed DS-230 Part 1 and it is recorded in the immigrant visa system. So this basically is where the particular child actually applies for the visa in order to acquire lawful permanent resident status. Now, for following to join cases, it is the date the parent files the Form I-824, which can be filed with the adjustment or the I-485, or takes a concrete step toward seeking LPR status. So that's where a lot of the ambiguities can come in so far as what exactly is a concrete step in order to go forward. Now, there's some examples in this particular case. Let's say a son who is 22 years old and 2 months old on the date his visa number becomes available, which may or may not be the date of the approval of the petition, whose parent's petition had been pending for 2 years and 2 months. This child would remain eligible as a child to obtain LPR status as long as he pursued LPR status within a year. Now, let's say example number 2. An I-130 was filed in 1998 when the derivative beneficiary was 20 and approved 1 year later. But the priority date was not reached until 2003. The child would not be eligible for benefits because he would have been 25 in 2003 and considered 24 under the CSPA, and because the age would be 25 less than 1 year after the petition was pending. So you can see there's all kinds of issues as to when someone is or is not eligible under this particular case, but at least you get a good idea of what you need to look for. Okay, more on the coming videos.